order. This meeting is held in accordance with the Open Public Meetings Act 10:4-6 at SEEK. Annual notice having been forwarded to the New Jersey Herald and the New Jersey Sunday Herald and posted on the bulletin board maintained in the municipal building for public announcement. Will you please rise and join me in a salute to the flag?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, call the roll.
Mr. Sherla, Mr. Diamond,
Here.
Ms. Dora, Mr. Catamick,
Here.
Ms. Crock.
Here.
Councilman Kucevich.
Here.
Mr. Metzalowski.
Here.
Mr. Rossi.
Here.
Chairman Wright.
Here.
Mr. Tappan.
Here.
Mayor Galati. Here.
Okay. All right, next item is minutes. A motion is in order to approve the meeting minutes of February 3rd, 2026. Do I have a motion to approve the minutes?
So moved.
Motion in a second.
Mr. Diamond,
Yes.
Mr. Catamick,
Yes.
Ms. Crock.
Yes.
Councilman Kucevich.
Yes.
Mr. Metzalowski.
Yes.
Mr. Rossi.
Yes.
Chairman Wright.
Yes.
Mr. Tappan.
Abstain.
Mayor Galati. Yes.
Okay, next item is resolutions. We have none at this meeting. Next item would be correspondence. We have none. Escrow refunds, we have none. Bills, Mont McDonald, Dolan and Dolan, and New Jersey Herald. Do I have a motion to pay the bills?
Motion. Second. Bill.
Mr. Diamond,
Yes.
Mr. Catamick,
Yes.
Ms. Crock.
Yes.
Councilman Kucevich.
Yes.
Mr. Metzalowski.
Yes.
Mr. Rossi.
Yes.
Chairman Wright.
Yes.
Mr. Tappan.
Yes.
Mayor Galati. Yes.
Okay, next item is discussion. Do we have discussion on something, bills that
No, you go. Okay.
303 Lakeside, or is there something you wanted to? That,
We can put that at the end.
Okay.
Yeah.
okay, okay. Old business, we have none. New business, we have none. Oh, yeah, okay, we'll talk about that at the end, the small grant. Continued applications, we have none. So the first new application will be,
Do you want to say this is not if anybody's here?
okay, we can do that. The second application is Wilma Peterson, 66 Ithanel Ave. That application is gonna be carried to the March 17th meeting without notice. So if you're here for that application, it's not going to be heard tonight. It'll be heard on March 17th.
Was that requested by the
Yeah.
applicant?
Mhm.
Okay,
So do we need a motion to carry that, Bill?
yes.
So moved. Second.
Mr. Diamond,
Yes.
Mr. Catamick,
Yes.
Ms. Crock,
Yes.
Councilman Kucevich.
Yes.
Mr. Metzalowski.
Yes.
Mr. Rossi.
Yes.
Chairman Wright.
Yes.
Mr. Tappan.
Yes.
Mayor Galati.
Yes.
Okay, first application, Michael Gruber, 16 Oakdale Ave, block 50509, lot 17.
That initially was presented to the board at its meeting on November 18th. So only those members who were present and listened to the application could participate. This is a youth variance application, so it's only the four members that would participate. So hopefully we've got enough. It looks like we do. Everybody, who was here for the November 18th meeting and remembers the.
And then I will be here. So. Yeah, I think we have one.
We'll be here.
Yep.
Well, you guys are coming back, all right?
They've already got their candy, I'm not sure.
Okay, so we have a quorum. We have 1, 2, 3, 4, 5, 6. We're good to go.
You good, Mr. Hepworth?
Yeah.
Thank you, Mr. Chairman, board members, Burton Heffley on behalf of the applicant, and as we stated, it's the continuing application of Michael Gruber for the property at 16 Oakdale, which is a lakefront lot where he's proposing the construction of a dock. So we previously appeared on the application and we pretty much went through the entirety of the application. It was presented and we pretty much completed everything. And just specifically by way of recap of the prior meeting, we went through the variances for this dock, which is 50 feet from the lake, the structure being within 50 feet of the lake, and the dock width. And both of those things were testified to essentially as hardship variances due to the size and configuration of actually the lot vis-a-vis the very narrow cove If the board remembers, last time around, we submitted applicant exhibit A. I just want to hold that up one more time for you. And, that applicant exhibit A showed, the cove, which is relatively, as you can see, narrow. And this is the, proposed dock. This was a previous dock, and, what we testified to in terms of the variances, again, this very narrow cove, dock going into the cove doesn't make sense because it bisects almost half of the cove. So this dock makes a lot more sense. It's actually smaller than what could be built. This is a 20 by 20 dock with the testimony. A 10-foot by 50-foot dock would be 500 square feet. This is only 400 square feet, so it's actually a smaller dock, and it's being located for the applicant in a landscape buffered area.
Most of the
So,
dock is on the
Yeah,
land.
most of that is on the, I mean, how much of it is out in the,
Well,
it goes past the seawall?
very little, about 5 feet. And the reason for that is because structuring it out into the water just doesn't make sense. It bisects this cove. So running it along the shoreline makes more sense than sticking it out into the lake. So most of this dock, 80% of it is actually
On the land.
on the land. That's correct.
Okay.
So, and essentially the argument was that this is a better design and that these benefits outweigh any detriments. And that was pretty much the extent of all of the testimony on the application. We were just about done, but we did have some comments from the neighbor. And the neighbor's comments surrounded, the deed, the subdivision deed, which created this lot. And the comment of the neighbor was that that deed perhaps, prohibits, the construction of a dock. And that came at the end. The applicant, was not of that opinion and felt the dock could be built. However, Mr. Haggerty, and rightfully so, wanted to review, those deeds. In terms of that final issue and whether there was a prohibition against that dock. And he in fact did make that review and issued his opinion letter to the board dated November 24th, 2025, which essentially comes down with the opinion that the dock is not prohibited. But I'm going to let Mr. Haggerty speak to that himself.
We heard the application, we heard from the neighbor. The neighbor presented documents, and frankly, it's difficult for me to sit and review a stack of deeds during a meeting. So I appreciated the opportunity to take them back to the office and go through them and render an opinion. And I did, as indicated, through a letter of November 24th. And there are deed restrictions in the chain of title pursuant to a settlement agreement. And the deed restriction prohibits constructing a primary structure on the lot. The permitted primary structure is a single family home. There is a garage on the property that already has a restriction against residential occupancy. So it's a garage for Mr. Gruber's property across the street and not to be converted into a home. There's also a restriction against parking of boats, and it defines what parking of boats would be in the area where the proposed dock. The language doesn't say you can't place one there temporarily. You could take one there on a weekend or something of that nature without violating the restriction as I read it, but you couldn't leave it there for the season. There's a 10-foot non-disturbance restriction area that's referenced, and it's shown in an exhibit that Gary Worley, a surveyor, provided. And it talks about for a continuous period of 5 consecutive days or portions thereof. And it would not include any boat or watercraft floating on the surface of Lake Atacon. So it's designed not to have the stacks of boats on the shoreline. So my opinion is this is not a primary structure, that it does not violate the restriction that they intended to. They certainly could have done that, but the language isn't inclusive of the dock. It says primary. That's my review.
Okay.
And the only other thing I would add to the application is that Mr. Haggard, we did produce also the permit from the state park, from the DEP permit dated April 18th, 2025. And Mr. Haggerty asked that I submit the backup application that went with that. And I did submit that to Amy and to Mr. Haggerty, and that backup documentation shows that the dock approved by the state is the exact same dock that we're proposing here with the municipality, which was the point, is to make sure it's the same thing. And I did provide that backup to the board and to Mr. Haggerty, so that issue's also been addressed.
That document was referenced, and I wanted to see it to make sure that what we're looking at is what the DEP was looking at, and it appears that that's the case.
Okay, so that's, I think that addresses the final issue that was brought up, and that's the extent of the application.
Okay. All right, I mean, any questions of the applicant? Well, see, I mean, you did your homework like we asked you to do, and you got the documentation we needed. And in the our attorney's eyes, it's perfectly legal to do what you want to do, so. No questions of the applicant? No? None?
You had mentioned a hardship, and maybe a question more to Bill. Is a hardship related to a hardship or benefit for the community surrounding the property?
Well, no,
I think of a hardship as like a fire.
right,
The fact that, I think you had mentioned that the hardship was irregularly shaped property. The property didn't become irregularly shaped, it was purchased that way, so there wasn't any more of a hardship that's happening now than was happening before.
I think the hardship that he's talking about, and maybe it's the benefit as much as the hardship, is that the channel is so narrow. That you don't want to have a small, 4-foot wide dock go out, because it would interfere with the channel conceivably. It's so narrow there. I think the benefit in having a dock 80% on the land with really just the face of the dock in the water probably is a benefit for the other users in that area. Our ordinance really wouldn't prohibit you from extending a dock out that way, but functionally, I think this would work better than having an extended dock into the channel.
And I guess the question, does the applicant have any other docks that they have,
No, not on that piece of property.
but on the property across the street?
The property across the street?
Their house?
Yes,
They have docks there.
yes.
How many boats does that dock support?
It varies. There's a boathouse there. There's a boat in the house. But I would add also to this, the question you had with regard to hardship, this configuration also, I think, very well fits the C2 variance requirement of special reasons, because this planning approach to put this dock along the seawall and on the land really is because of this configuration, right? That would be the special reason, that this configuration lends to this configuration being a better utilization of the property than putting the dock into the lake. So I would tell you that it not only fits the hardship requirements, but I think it would also fits the C2 special reasons variance.
Okay.
And the other point that was made was there was a dock there before,
Yeah.
so this is a replacement dock. The other dock was more into the channel, more of a traditional, I guess you'd say, dock. This I look at almost more as a deck than a dock.
I was thinking it more as a deck than a dock.
Yeah.
Sorry.
But I was just wondering, since it was never really mentioned, did the prior owner actually know that the dock was there, or did not think it's important when it was revealed through the prior owner's observations when the lake was lowered? I mean, what's an archaeological find versus, something of near-term use that needs to be repaired, was the way I saw that. Okay, I don't want to belabor the point, but thanks.
Perfect. All right, no questions of the applicant? At this time, I'll open this application to the public. Does anybody from the public wish to comment on this application? The public.
Let me give you the podium.
You know,
It's the deed. I put it in the back.
It's already in our packet. He said copy of the deed.
Okay, okay. Yeah, in my letter, I provided a copy of
Okay.
the documents. These may be the same.
I think it's the same one.
Here's. Just for.
This is all the same deed, I take it.
Mr. Hagerty, I didn't see your November 24 opinion letter, so I'm not sure if this is the deed that you were referring to
It's one of the deeds.
in your letter. Okay, thank you.
Mhm.
Good evening, Mike.
Yes, yes.
Well, no, it's true.
Okay. I didn't know that.
That mean we have to do.
He didn't let us know that.
He's in his uniform.
All right, we're good?
Okay.
Good evening, Mark Brancato with June Brancato on behalf of Constance Madden, who resides at number 10 Oakdale, which is adjacent, 2 doors down from the applicant's home. The application is deficient in several respects. And I'll start with where the applicant's counsel left off in terms of the special reasons. Number one, in terms of the archaeology of there was a dock there before, and if we look at the agenda for tonight's meeting, the agenda for Michael Gruber, applicant is proposing to replace old dock with new dock. Well, there's no evidence has been presented that there was an old dock there. What we do have is the applicant's testimony from the November meeting where he said that dock was gone in the 1970s, 50 years ago. So it'll be one thing, one of the board members said, well, what happens if a house burns down or a piece of it burns down? Can't you rebuild that? Of course, that's not the issue we have here. There is no dock. There was no evidence of an old dock that we're now replacing. So this kind of off the cuff, we're just replacing an old dock approach to this application is misplaced. This is a variance application. This town, in its wisdom, in its stewardship of this lake, adopted a master plan, which was very specific. You can't build within 50 feet of the water, which is why we're here. At the last meeting, there was a suggestion that, well, we really don't even need a variance because we're just replacing an old dock. And in fact, there's some cribbing there. That was a word used. No, that's not what this is about. This board is a steward of that lake. And the ordinance says you can't build within 50 feet. Now, this applicant comes in and says, well, I have a hardship. Well, where's the hardship? As one of the members pointed out, this was not a little piece of property that maybe an old resident lived on and their dock fell apart and I want to build a new dock, but geez, I'm really constricted. So can you let me do that? No, this was a parcel that was subdivided. This lot was created intentionally in its configuration. The applicant lives across the street and has a beautiful home, has a boathouse with a boat in it, has places you could park a boat, places you could sit. Now, at the last meeting, the applicant talked about, well, we're really building a deck. It's not really a dock, it's the deck, and we're not going to put boats there anyway. Well, now it's a dock. And in fact, so generous is this applicant that he says, we're not asking for a dock that we could ask for that goes way out into the lake. No, we're doing something more conservative. We are going to run it laterally. The expression used was, it's a planning approach to run it laterally rather than out into the water to make it less offensive, to make the prohibited dock less offensive, then we could come to this board and ask for it. That's the applicant's approach. The test, which has not been satisfied, and there's no expert testimony here in regard to the satisfaction of the negative and positive criteria that we're all familiar with. There's nothing. So we have the applicant's testimony, which is, I want to put a dock there. I want to put a deck there. For what? Let's look at the deed, which I'm referring to, and I passed out to everyone. It's a long deed, but I wanted to be able to discuss it in an organized fashion. So I've numbered some of the paragraphs beginning on page 2, but let's look at page 1 of the deed. Page 1 of the deed dated March 11, 2011 is between John and Diane Lawyer, Loyer, to Michael Gruber and Larissa Gruber. So this is 2011, prepared by Douglas Henshaw, an attorney at the firm of Porgio, Bromberg and Newman, not my client's attorney. I'm sorry?
One.
Oh, just looking at the first page. So the page, so this is between the prior owner and the applicant. I don't believe this to be the subdivision deed. It refers to the subdivision deed of even date. And the second page, which was May 11, 2021. And I believe Mr. Haggerty referred to that earlier. But let's look at the second page. Lawyers live and die by language, and Mr. Henshaw is a fine attorney at a respected Morris County firm. He drafted this deed on behalf of his clients, the lawyers. And let's look at the language he chose to use. In the first paragraph, I put a number 1. That's my handwriting there, and I did some underlining. But the intent of this deed, subject to the additional terms and conditions set forth here and below as restrictive covenants affecting the grantee's use. The grantee is this applicant. Restrictive covenants affecting the grantee's use. So when Madden bought this property, when Gruber bought the property, he knew there were restrictions. In fact, part of the subdivision was creating these restrictions to restrict the grantee's use, to restrict the Gruber's use. And let's look at those. For the benefit of the owner of the premises known as 10 Oakdale. That's Madden. 10 Oakdale goes on to describe in the second to last sentence, hereinafter, the Madden lot. So my client, Miss Madden, lives at number 10. Her property is referred to as the Madden lots. So this restrictive covenant is for the benefit of Madden at the detriment of Gruber. Gruber negotiated this 15 years ago as part of the subdivision. If we go down to section A, it has a capital A, I put a number 2 there. The property should not be developed. Now let's go back for a second. In paragraph 1, it talks about the one I identified as number 1, restrictive covenants affecting the grantor's use, development, operation, and maintenance of lot 7, that's this lot, hereinafter the property for the benefit of the Madden lots. Number 2, the property should not be used or developed as an independent principal use. But we go on. Notwithstanding the approvals granted for the property, those approvals would be the May 11, 2011 subdivision, the property and the existing garage structure hereinafter the accessory garage. And let's just stop for a minute. There's a distinction in this restriction upon Gruber between the use of A, the property, which is the land, and B, the garage. We can focus on the garage, and we will, but that's not what this is. It's both. It's the property, the real estate, and the garage are restricted. And if we go on, shall be used only as an accessory garage. So we know it's to service the house across the street. All well and good. If we go down to the next page, where I put in number 3, there's the Roman numeral 2. Vehicles, boats, etc., shall not be stored and parked in the easterly portion of the property. The easterly portion of the property, and this is important because this dock that we're talking about is to the east of the garage. So the garage is our static reference point to the east of the garage. And what is the easterly portion of the property? The easterly portion of the property shall be defined as those areas of the property located more than 10 feet easterly from the existing garage at the site. We go down to Roman numeral number 3, notwithstanding the foregoing, no more than 3 watercraft may be stored on the property. The easterly portion of the property, if we go down, is anything that's 10 feet beyond the garage. So if we face the garage and we look to the east, we look to the right, we have a 10-foot buffer, and we'll talk about that in a minute. We have a 10-foot buffer. If we took a tape measure from the garage, 10 feet, we put a stake. Everything from that stake to the water is the easterly portion of the property. So we have 2 things. We have the garage and we have the property. If we go down to the section HI, we have I. The restrictions described herein also prohibit disturbance or alteration to the existing conditions of those portions of the property located within 10 feet from the southerly property line, the line abutting Oakdale Ave. That's this area of disturbance, and that's a red herring here. That's not what we're talking about, this area of disturbance. That's not part of this. That area of disturbance is not where this dock is going. That doesn't relate to the garage. So that's been referred to, but that's a red herring. The restrictive covenant provides that there can be storage within those 10 feet of the garage. That's the area that you can modify. We go down to where I have number 4, which is letter J. The accessory garage and any replacement garage structure permitted shall be constructed and maintained such that the structure reflects the use. Any replacement garage structure on the property shall be substantially similar in the footprint and the same location as the accessory garage. So the drafter of this deed and the purchaser of the property, the deed cites consideration of $200,000. The Grubers bought the property knowing that if that garage comes down or has to be fixed, or we have to tear it down or it burns down, you have to rebuild it in that same footprint. It doesn't say you can build this anywhere you want. It says in that footprint, because that's the property. The property can be used in that footprint. You can put the garage back there, not to the east, because we know to the east, that's not to be touched. That's what Gruber agreed to. If we continue on, we have the section, if we go to the next page, page 4, the last paragraph, the restrictive covenants shall be recorded in the chain of title for the Gruber lots and shall run to the benefit of the Madden lots. That's why we're here. Why do we have this restrictive covenant if it wasn't in the intention of Mr. Gruber when he paid $200,000, got this property subdivided from the lawyer parcel, if he didn't intend to agree and to abide by these restrictions that were in the very deed that he accepted and that Mr. Haggerty referred to? The language here is very specific. Here's what we don't see. We don't see language here that is similar to the you can rebuild the garage. We don't see language here that says, oh, and by the way, back in the 70s, there used to be a dock there. And we're going to depict it on this map. And you could rebuild that dock because that, runs to the benefit of the Madden lots. In 2 places, this talks about benefiting the Madden lots. Now, Mr. Gruber may feel, well, this is unfair. It's too restrictive to me. I should be able to put a dock there. This is my property. It's part of the plan. Well, there's no expert talking about that, number one. But Mr. Gruber bought this lot knowing it was restricted. And if he didn't want the restriction as to the construction of the dock he's asking for tonight, he should have put it in there. Could have just as easily had his attorney and Mr. Henshaw insert a paragraph that said, you can build a dock. It doesn't say that, but it's very specific as to what you can't do. And what you can't do is do anything once you're 10 feet beyond the side of the garage to the east. If we look at the deed, if we look at the map that's attached to the deed, it's the same survey that's before this board tonight, except with the overlay of the proposed development. And this is from January 24, 2011, done by Gary Worley. This is the survey. Noticeably absent from this survey is any depiction of remnants of the old dock. The old dock that the agenda says replace old dock with a new dock. There's no depiction of the old dock there. What we do have is other easement areas. We have the hatch marks for this a drainage easement. So Mr. Worley did a very thorough job preparing this document. I suspect that the applicant, the lawyers, L-O-Y-E-R, the prior owners, when they did the subdivision, did a similarly thorough job in preparing that application. The absence of the remnants of the dock that they seek to replace tonight is instructive in that there was no dock there, not in the time that Mr. Gruber negotiated to purchase this property, not during the time of the subdivision. There was no provision in the subdivision deed or the subdivision resolution of approval stating that, and it is further resolved that this applicant may replace a deck or dock that was there back in the 1970s, depicted on the subdivision map as follows. That language doesn't appear there. This negotiated agreement between the Madden lots and this applicant is silent as to the construction of a dock. Bear in mind, recall the testimony, I listened to it, I'm sure you all did too, from the November 11th meeting where this applicant said, we're not going to put a boat there. We don't intend to put boats there. Now, I'll leave you with this. There's a provision that is in this deed that has been cited by Mr. Haggerty in regard to boats. And if we go to the third page of the deed under Roman numeral 5, for purposes of this of this deed, and any restrictions, outdoor storage shall be defined as parking, deposit or presence of any vehicle, boat or watercraft anywhere on the property for a continuous period of 5 consecutive days or portions thereof, but shall not include any boat or watercraft floating on the lake, the surface of Lake Hopatcong. Pretty specific language. It doesn't say any boat or watercraft affixed to the dock which may be constructed on this property. If you enter into an agreement, which I respectfully assert that the Grubers did in order to obtain the subdivision, which they did to benefit their language, not mine, the Madden lots, well, now you have to live with that. And that's what we have. And for those reasons, I respectfully assert that this application should be denied. Thank you.
Just a couple of observations. In terms of variance application without a prohibition against building within 50 feet of the lake. And you have a lot of disappointed people that like attack on lakefront properties that are told that they can't build a dock or a deck by the lakefront. That's the community scheme. It's the community scheme in all lakes that I'm familiar with, and I'm familiar with lakes. Yeah, that's why you buy a lakefront property. The second is on page 3, section cited, paragraph G, number 2, with the number 3 inserted next to it, vehicles, boats, watercraft, recreational vehicles, trailers, or similar items shall not be parked or stored on the easterly portion of the property. The word stored is critical there. The easterly portion of the property shall be defined as the property located more than 10 feet from the easterly from the existing garage on the site. So that area is restricted. But then, as earlier cited in subparagraph V, about almost halfway down there, it says, for purposes of this deed and any restrictions described herein, outdoor storage shall be defined as a parking placement or presence of any vehicle, boat, or watercraft anywhere on the property for a continuous period of 5 consecutive days or portions thereof, but shall not include any boat or watercraft floating on the surface of Lake Hopatcong. So that contemplates the Gruber property owner being able to bring boats down over the weekend, leaving boats, leaving trailers, leaving recreational vehicles in that buffer area. As long as it's not for more than 5 days, that would constitute storage. So they have use of that, limited to that 5-day period. On page 2, subparagraph B, capital B, the property and structures existing thereon shall not be used or occupied for any principal use, including but not limited to residential dwelling use. Right? And I know you can say, well, wait a minute, it didn't say you can put a dock there, but nowhere do I see it say you cannot put a dock there or you cannot put a deck there. I don't see that language. That just as easily could have been inserted in the deed as a description. So I think that cuts both ways, frankly.
Just a question on that point to help me understand. I know you said earlier that many people buy lakefronts with the expectation of having boating enjoyment through their property. But don't most of the properties that already exist have docks, and it's a matter of maintaining and replacing and repairing rather than expanding? And I would make the observation that I've seen many other lake pack-on committees, such as land use, propose the opposite open space initiatives so that everybody in the lake can enjoy the lake and not the people with the nearest house to the shore. So wouldn't that be a counterbalance to
And to help
expansion?
preserve that, we have a setback requirement from docks to property lines, but
Mhm.
we do have applications, boats are larger. We have patio boats, the pontoon boats, I call them, they're wider. So we have applicants coming in and saying, geez, I want to reconfigure that well, so I can accommodate the boats that are really being used now, and they're much more common now, so we get a lot of applications seeking that type of relief, but certainly a lakefront.
But
property-
all I'm saying, it's a counter, open space, having things that aren't fully developed so that riding along the shoreline is not like walking down Park Avenue. You know, that there's some green
Yeah,
between the buildings. And the second point, the point that they didn't explicitly say you can't build a dock versus, doesn't that somehow get negated by the overarching statement that it has to be done for the benefit of the adjacent property? So if the adjacent property said, go nuts, build a big dock,
this is.
that would not be an issue.
This is for
But
the
that other
benefit of-
language.
yeah, this is for the benefit of the adjacent property, in my view. It
Which is defined.
incumbent upon the property that's being benefited to amplify these restrictions. So if there was an intent, there's no objection to putting a trailer there for 4 days, not a boat hoist there for 4 days.
But a dock for
I don't
15
get-
years? But a dock for 15 years would be
Dock
different.
that's a deck that's flush with the surface of the ground.
Hmm.
What's the issue? Maybe, you know,
Well,
it's-
it's.
I mean, did
well,
you go
what's-
down there, James? Did you go look at it?
Yeah,
I mean, it's kind of there's no traffic there. It's a dead end. I don't even know how deep the water is over there. Is it 3 feet from the, maybe? I mean, yeah, when the lake is at its peak.
Kayaks.
Yeah, so, I mean, you can't even drive a boat in there, really.
Right.
I mean,
But,
If I may.
but I think just on a logical standpoint, if we say the agreements are to the benefit of the person to my left, and the person to my left says, I'm not feeling the benefit, isn't that sufficient to define what's allowed or not allowed? I'm just saying,
Yeah.
from the logic of what was presented.
Bill, can I ask a question? Is there anything that we just heard in this testimony change your opinion of the variance?
No.
Okay.
Not as I set forth in the letter.
Can I ask a question to the attorney representing there's gotta be something more to it. What's the rub here?
I'm sorry?
What's the rub here? Is this a neighbor thing that, I mean, people don't get attorneys and bring them and say, I'm gonna protest, this language of this particular deed. There's gotta be something more to it.
To address your question, there is nothing more to it.
Okay.
There is this negotiated settlement agreement, there is this deed,
Both testimonies from two attorneys.
and
it just doesn't specify that he can't put that dock in. There's nothing, there's not a,
Says you
Correct.
can't put a principal use, you can't convert the
Yeah.
garage to a house.
Yeah.
But curiously, it does allow you to put trailers and everything else there for
Yeah.
4 days over a week, extended weekend.
But following that logic, you could put a dock there for 4 days.
You could put a temporary dock and lift it and put it back, I suppose, but
But if everybody's looking at the language, I agree. It'd be nice if neighbors could agree on a common ground.
I mean, to me, this obstructs nobody's vision, nobody's access to the lake. Nobody, I mean, this is just, there's nobody going in that cove other than Mr. Gruber, as far as I mean, what is I don't know, it's a minimal, I mean, if you wanted to go out 50 feet into the lake, I'd say, okay, we got a little bit of a problem with this. You're not even going out in that, it's not even hardly the lake. It's like a swamp over there. It's not really.
I am correct that the deck would be level with it's not a raised deck.
No, level with the land. I have just a couple of quick comments.
Good.
So, in terms of what your question, what's the road here? this, I was initially involved with the original subdivision and then Mr. Henshaw handled the rest of it. And that subdivision of that piece of property, and the objections of, Ms. Madden, cost Mr. Gruber some $60,000, 10 meetings, and a resolution that's about 100 pages long. So there's the history, number one. Number two, obviously, Mr. Brancado's great attorney, has been around a long time, and he spoke very long. And when you speak a long time or you write a big, long brief, that's usually because you don't have anything. Now, the letter, opinion from Mr. Haggerty is over 50 pages long. And he spent a lot of time on this. Mr. Brancado admits he's never read it. You haven't, right?
I'm not answering your questions. I'm not testifying.
You're not this.
But what I do know is that this is your second night and you still don't have an expert. And we're gonna have a conversation, talk about how long I went, and I went long because I don't have anything. I don't see, unless there's someone here who hasn't identified themselves, you close your application, there's no planner, there's no expert.
Just by way of correct, my letter is for, well, actually, got 3 pages in the line, the rest of it's attachments.
I have one
Who's
question.
getting the bill for that?
I have a question. So Mr. Haggerty's letter here, where he clearly opines that this dock is not prohibited. What exactly, Mr. Brancado, in this letter, do you not agree with? What is it in this letter? Point
I've
it out.
articulated my position very well.
But can you point out in this letter why Mr. Haggerty?
And Mr. Haggerty's, I did not have the benefit of Mr. Haggerty's letter. I have the benefit of the deed, which is part of the public record, which runs with the land, which is in the chain of title of the applicant,
I understand. but Mr.
and
Haggerty-
provides an agreement on the part of the applicant that I'm not gonna do anything with this property. We don't even need this if the whole thing is to say, hey, Gruber, you can't put a house there. You don't need this. Of course you can't put a house there. It's not big enough. So why do we have a restrictive covenant to say you can only use this as a garage? We know you can only use it as a garage. You can't put a house there because if you could have, well, then you would have, or maybe somebody else would have. So why do we have this language? To restrict the use of the property, which is you got a garage there, that's it. If you want more,
Please.
have your lawyer, have Mr. Heffley, who's a fine lawyer and knows his way around the zoning law, put it in there. And at the option of Gruber, he can build whatever the heck he wants, but it doesn't say that.
The restrictions in here, Mr. Haggerty spent a lot of time going through each and every one.
That-
Okay, so now, can I just speak for a second? Thank you. Now, he goes through this, and he goes through it very clearly. Now,
Did a very
you are
good job.
taking the position that, your position is that the property is restricted. I agree with you, it's restricted, but it's not restricted with regard to the construction of a dock. And that's clearly the opinion of the board attorney. He has reviewed the deed that you're talking to, that you're speaking about tonight. It was reviewed in detail by Mr. Haggerty. Okay, he comes down with the dock is allowed. All right. You haven't looked at why he comes down that way in his letter. So I understand that you're interpreting the deed. Mr. Haggerty interpreted the deed also. I just want to point that out to the board.
Yes, no, you're 100% right. We're both having our own interpretation. That's
Secondary.
all.
Secondary. The deed specifically says that the restriction shall not apply to watercraft floating on the surface of Lake Apacon. Well, if it doesn't apply to watercraft floating on the surface of Lake Apacon, clearly there was an intention that there would be floating on Lake Apacon watercraft. And that is a dock. And the deed says it doesn't apply to that. The restrictions do not apply to watercraft floating on the surface of Lake Apacon, period. So clearly a dock was anticipated.
If I could address that, Mr. Heffley, that could refer to boats that are out in the lake that are moored with a weight and a floating bottle that you see where people tie off to. It doesn't say dock.
Okay, fine. Lastly, whether this is an old rebuilt dock or whether this is a new dock makes no difference in terms of the application. There may have been a dock there. There are definitely historical markings of the dock. The cribs are in there, but it doesn't make any difference. Cribs, no cribs. This is an application for a dock. And the application for the dock is the same, whether the old one was there or not. We're not establishing some prior non-conforming use here. And lastly, well, not quite lastly, but the issue of the 10-foot restriction. The Worley survey, and I hold it up here, it's clear, the easterly side has nothing to do with the dock. The 10-foot easement is clearly right here, it's along the road, and it's designated, and it says on here, 10-foot wide, non-disturbance restriction area. See agreement for details. We don't have to guess where the 10 feet are. The 10 feet are right up, they're designated on the survey, they're right up against the road. And that restriction has nothing to do with the dock whatsoever.
Yeah, there I disagree with Mr. Heffley. I think that there's two restrictions. One is along the road and the other is anything 10 feet to the east of that. But I don't think that hurts you, frankly. I don't think we have to spend a lot of time on
The
that.
survey designates that area. And then lastly, the very last point is, Mr. Gruber paid $200,000 for this lot. And it is a separate lot, and it's a separate lot. It's owned by him. It has restrictions on it, but it's a separate lot. And a lot on the lake is allowed to have a dock. And that's exactly what he's proposing here. And he's proposing a dock that fits, that makes sense in terms of the waterfront, is well buffered, is not seen by anybody, does not intrude on the lake, the small area of the lake where it's located. And again, most of it is on the land. So I think this is a very, very approvable application, despite Mr. Brancato and his client's objection to it. I understand they don't want it, but his interpretation of the deed is incorrect based upon Mr. Hagan's letter, and that's our application.
Just a question on that point. I would agree, in most cases where you have a lot, they don't, do they also have the language that it should run to the benefit of someone else? Where if I read that, I'm kind of getting the impression that all things being equal, when it runs to the benefit of someone, they get 51% of the vote. If a vote needs to be made about anything that's in question. Is there any restrictions you see for the benefit of Madden lots that would say, well, it's for your benefit, except in this area, this area, and this area? Because other than the lakefront,
Well, the benefit to that is clearly was that there was not going to be any additional structure in terms of a house or anything located on that lot. That was the intention here, and he understands that he cannot build any other structure in terms of living quarters, and it has language in there, kitchen, whatnot, you can't have any of that. And no kitchens in the garage, so it was clearly intended that there would never be any additional living on that property. And that is really what this restriction is all about. It has nothing to do with docks. It has to do with structures for living quarters and not turning that lot into another house and garage, if you will.
I mean, there's nothing in that deed that says a dock can't be placed there. I mean, if it specifically said that, then we wouldn't be here talking about it. I mean, it doesn't say that that's not allowed there.
and certainly hardships, if this was a dock that was needed because there are no other docks available to the person. I mean, I see.
I don't think.
This is a separate piece of property.
You can't look at the Gruber's other property.
Yeah, I mean, this is-
Wasn't earlier, the impression I got was the carve out was specifically for the benefit of the property across the
It
street,
is,
rather than a carve out to stand on its own, to do whatever
Yeah.
on its own.
but it is for the property across the street, we're correct, but we've got to look
And
at
the
this
par-
particular property.
Yeah, but it's different from other properties in that it has that linkage already defined and it already has for the benefit of another party already defined, which makes it more unusual than a case in isolation. And I don't want to monopolize, it's just things I'm having difficulty trying to square up.
All right, you're done, Mr. Heffley?
Yes, I'm done.
You're good?
Well done.
Any other members of the public wish to comment on this application? Seeing none, I will close it to the public and bring it back to the board and wait for a motion.
Make a motion to approve the application as the question.
I'd like
This requires 5 affirmative votes, it's a use
All
fair.
right, we have a motion, a second.
Okay, Mr. Diamond,
Yes.
Mr. Cadmick,
Yes.
Ms. Crock,
Yes.
Mr. Maslowski,
No.
Mr. Rossi,
Yes.
Chairman Ray.
Yes,
1, 2, 3, 4, 5 yeses.
Okay, thank you.
okay. Good luck.
Thank you.
Thank you.
Okay. All right. Okay, the next application The new application, it's Bleddy Zaku, 53 Point Pleasant Road, lot 10810, lot 9. Is Mr. Zaku here? Step right up.
Wait, three, that's
Here we
it.
go. Yeah, you could tell them they're,
Unusual. I know what the property is, and it's just.
We're dancing. Oh, me, you're dancing too.
I understand.
That's easy.
I understand. But matter what they do. And if somebody bought that property with health, that kind of additional language, yeah, it does stand
Yeah.
more on its own.
Yeah. What is there anything in there that said they could? Okay.
Where's-
Missing one?
This way?
That's just done.
13.
Right on.
53 in purple, is you wrong?
Thank you.
Oh, that's the one. that's the influence.
Okay, we're just waiting for one more member to come back. The mayor. I don't know. Without it.
Let me go find it.
He was right behind me.
I'll go get it. I'll go get it.
Did you tell her?
I'm sitting.
lost.
Took a long
The
time.
car's still here. There she is. Take her keys.
This is by the yacht club, right?
Yes.
Yeah.
Pull down. Next word, you say, hold on.
It's a long.
Okay, we're good to go. All the members are back.
Okay, good. Thank you, Bernd Heffley, on behalf of the applicant here, Bleddy Zaku. This property is at 53 Point Pleasant Road. This application is for the construction of a new residential home on this lot. The lot has an existing older home on it that's not in the best of shape. And the proposal here is to take that home down and invest the funds to build a new home on this piece of property that's more suited to the property in the neighborhood. The property itself it's unusually shaped in that it's very long and narrow. And also it's accessed by virtue of easements out to Prospect Point Road. So that makes the lot a little bit unusual. But despite the shape of the lot, it does drive some variances for the application, but the variances that it triggers are really fairly minor. And there's really not any overbuilding of this lot. And by way of example here, we are very close on most of these variances. We have side yard setbacks 9.9. And we need 10. We have 9.9. We have combined side yards of 19.9. We need 20. In terms of lot coverage, maximum building area, 15 is what's allowed. We have 15.8. Lot coverage, similarly, 25% is allowed. We only have 27. So, and the engineer will get into that and why those variances exist, but they're very minor. And I point that out only so that the board understands that we're not trying to bite off more than we deserve in terms of this lot. So, with that being said, Tom Graham prepared the plans that were submitted to the board. He's here tonight to testify so we can swear him in and then we'll go through what we've got.
Please stand, raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
And your full name, sir?
Thomas Graham, Graham. I'm a partner in the firm Dykstra Walker Design Group. I'm a licensed professional engineer. I have testified in front of this board on numerous occasions. I've been accepted as an expert witness.
You good?
So we're here today for block 10810, lots 8 and 9, more commonly known as 53 Point Pleasant Road. The property is generally rectangular in shape with dimensions of 65 feet wide by 325 feet deep. The lot has frontage along Lake Apacon and is surrounded with residential properties to the north and the south. The lot does not, excuse me. The The lot does not have any road frontage. It is accessed via a gravel and asphalt driveway across lot 8. So the lot that we're talking about tonight is lot 9, which is the smaller of the two lots and the one that abuts the lake. Lot 9 currently supports an existing single-family dwelling with a well and municipal sewer service. There's an existing dock providing lake access. Topographically, the property slopes from west to east towards the lake. Lot 9 is 21,294 square feet in area and is located within the R1 residential zone district. That district requires 15,000 square foot limits. As the property is along Lake Apacon, there is a flood hazard area and riparian zone. There are no wetland or transition areas associated with the property. While the existing lot is larger than the minimum required area, 21,294 square feet versus 15,000 square feet, it is much narrower than what is required. It's 65 feet wide at its widest point and 120 feet, where 120 feet is required. The applicant proposes to take down the existing dwelling and construct a new single-family dwelling, 2 sheds, a paver patio area in this area of closer to the lake, so that the lake could be enjoyed. The 2 sheds are required as the proposed new dwelling has no garages, so no place to store life preserves or other equipment or toys that are used or up in and around the lake. There will be a small increase in the impervious coverage on lot 9 from 5,471 square feet to 5,902 square feet, or 431 square feet of proposed additional impervious coverage. We have proposed to collect the roof areas and divert that to a dry well. When we analyze the increase in the impervious coverage, only 22% of the capacity of the dry well is being utilized. We are bringing the entire roof area to that dry well. So we are absolutely overcompensating for the increase in additional impervious coverage. We propose that the dry well have a grate on its top so that should it fill up, it would overflow, and the overflow. I'm going to switch plans here. These are the plans that were submitted to the board, and I have made no changes to them. Right now, I'm looking at plan sheet number 2. This is the location of the dry well, the box with the B in it. Should the grate or should the water start to overflow, the water will flow down the hill towards the water flows perpendicular to the contours. So any water that exits the dry well would not cross onto the adjacent property, it would flow across this property towards the lake. There are a number of variances as outlined in Mr. Donegan's report of 21026. Mr. Heffley just went through them again, so unless you want me to go through all of them again, I think they're identified in Mr. Donegan's report. But the lot width is 1, but that's an existing non-conforming condition, and there's no land available on either side for the property to be expanded. You can see on the survey that was prepared, there are 2 rectangles. Those represent the location of the existing houses on other lots. So this lot cannot get made any wider. With respect to the shed number 2, it is 4 feet off the property line, where sheds of this particular size, they're supposed to be 15 feet off the property line. But again, given the narrow width of the lot down by the lake area, we thought that this was an appropriate place to put that shed. The dwelling has a side yard variance of 9.9 feet. While the property is generally rectangular, it's not really rectangular. It tapers as it gets closer to the lake. So the widest part of lot 9 is where it butts up against lot 8. The house, we set it so that it was 10 feet off the sideline to the north. It's 10 feet off to south in the front corner, but because the lot starts to get narrower, by the time we get to the back corner of the house, we're at 9.9 feet instead of 10. The other variance for the house for side yard is the combined side yards are supposed to be 20 feet. We have 19.9. Maximum lot coverage, we're at 27.7%, where 25% is allowed. I think I already talked about how we were going to take care of that increase. We're actually overcompensating with the dry well. We can handle much more than the small increase of impervious coverage that we're providing or proposing.
Tom, just a quick question on that. I think
Just looking at your calculation for the impervious coverage, I think you included the deck.
That we did include it in the open, that it is, but we were just trying to be very conservative in our analysis.
So that you may not actually need that. So I think that would be a 22.6.
So it's better to have it than not need it, but thank you. We were just wanted to make sure we were conservative, we understand how big of an issue this is on the lake properties.
Okay.
Then for,
So just on that point, it would address what the Lake Hopatcon Commission pointed out.
I did not receive a copy of that letter.
She just gave it to us, yeah.
That,
But we get Lake Hopatcon letters on every application. And I believe that our plans do address their concerns in.
right, and I agree, most of the time it's like boilerplate, but they made a specific call out to impervious coverage, and are we really talking about 27 or 22? I know you were in terms of impervious coverage.
Well, 25% is allowed. Our calculation is that we're at 27.7%.
But
I have not done the calculation if we took out the deck,
okay, that would address or scale back or.
but we.
I think that would
also-
bring you under.
That would bring you
Yeah,
under the.
and that would be helpful. at that point.
But we've also compensated for that increase in impervious coverage by oversizing the dry well.
There you
go. Next up would be lot, or maximum building coverage, the proposed building at 50.8%. Again, that calculation includes the deck. So if we're gonna discount the deck, then we're gonna be under the 15%.
Well, the 15,
That's included in.
the 15, I think the calculation from the building coverage is correct.
Okay.
It was just the impervious coverage that was.
But again, if the building's a little larger, a lot of that is because of the height, configuration of the lot. And I was up to structures within 50 feet of the lake, proposed shed 1, we were proposing it to be 7.5 feet off the lake, so that your ordinance requires that it be 50 feet off the lake. Our lot does not front on a approved roadway, but we do have access through the adjoining lot along a driveway to the roadway, certainly sufficient for emergency vehicles to access the property. And then the last variant is there's a existing retaining wall along our southerly border. It is 1 foot off the property line. We're not proposing any changes to it. It's required to be 5 feet off the property line, but again, it's an existing non-conforming condition. So I mentioned earlier that the property was on Lake Hopatcon, so we have to deal with the DEP rules. So when we put the plans in the application together, we require 2 permits by rule for the construction of construction activities located outside of a flood hazard area but within a riparian zone, and 1 for the construction of non-habitable buildings, which were the 2 there. I'm not sure that those still apply, given that the DEP has recently changed the rules. So now I believe that we are under permit by registration number 4 for the general activities and permit by registration number 5 for the non-habitable building. But in order to meet those requirements, the shed has to be moved to be 25 feet off of the lake. Under the permit by rule, you could be within 25 feet if you were adjacent, or the property had an existing bulkhead, which we do, but they changed the language in the new permit by registration that says just 25 feet. So we're going to be relocating shed number 1 to be 25 feet off of the lake, so that we conform with the DEP rules, so that we can get that, but we'll still require a variance from the municipal code because yours is structures have to be 50 feet away. And this is a very small shed, about 100. It's a 6 by 8. It's really just for the life vests and things like that. Certainly not a habitable space by any stretch of the imagination. So we also have had some conversations with the adjoining property owner to our north. They, in general, we do the topography, a lot of it is going across our property towards his dwelling. He has stated that he experienced some surface runoff from this property. So what we're proposing is just to construct a 1 foot berm along the common property line. That way, any water that does come across this property will be directed down the common property line, ultimately to the lake, instead of going through his property. We also met with his engineer out on the site. The existing building today is a house with a roof, but there are no gutters or downspouts. So any water that lands on that roof sheets right off and then again goes towards that neighbor. What we're proposing to do is to collect the roof runoff with gutters and roof leaders and direct it to a dry well. That dry well is located at a point where when it overflows, it will not direct any water towards that neighbor. There is an easement across lot 9 at an access easement. The existing sanitary sewer connection is within the easement, but the existing driveway kind of meanders in and out of it. So part of this application is we're going to correct that easement to totally encompass the existing driveway and the sanitary sewer service line.
Cost lot 8, you mean, cost, yeah.
I'm sorry, yes.
I mean, I'm looking at this here, it shows an easement
Yeah,
right smacked up through the middle of the
well,
property.
the easement is along the southerly property line, and then the other line of the easement goes right down the middle. But it never covered the driveway that was there.
So that's a,
That's an existing easement.
that's a deeded
Yeah.
access easement to this
That's
other
correct.
property,
So
okay.
we're gonna revise that. I think when the easement was created, then they later came in and built the driveway, but didn't really pay attention to where the easement was.
Yeah, and to that end, so we did secure that easement now to run it through the center of the property. And the reason for that is that makes more sense to the neighbors from a planning point of view to
Yeah.
run it down the middle rather than to run it along the property line.
Well, I mean, the only thing is, I mean, if they decide to build a house there, where are you gonna run the driveway? You're gonna run it right
So-
along the property line?
If someone was gonna build a house there, the driveway would have to be reconfigured and that would have to come in front of this
Right.
board.
So right now, there's a deeded easement to drive right
It's
down the
right
middle of that
down the
other
middle.
lot.
And if they decide that they want to put a house there, then that easement will need to be relocated. And like Tom said, that would be in front of this board.
I just don't wanna have this guy build a house and all, and this property said, wait a minute, you can't.
No, we're gonna have, this is gonna be a permanent easement
Okay.
that runs with the land. And if it has to get modified later, it will. But for now, we're gonna run it right down the center and we have the agreement of that property owner.
Okay.
Is that property owner this applicant? I'm looking-
No,
No.
no, the last names are the same, but
It
they're
is
not
a-
this.
It is a removed relative, if you will. A removed relative.
Well, there is something on file, there is a deed, there is,
Leave that alone.
okay, well, I mean, as long as he has access to it, because he'd be landlocked.
We have, right, we have an access easement regardless, so, you know, even if that easement down the center were not there, we still have access to the property that's recorded today. So that runs along the property line, but the one down the center makes more sense, so that's the one I'm gonna provide a copy to Mr. Haggerty of that and to your engineer. That conforms to what's on.
So
the-
that's what we're gonna base, if this gets approved, that's what we're gonna base the approval on, is that access easement right down the middle of the
Correct.
property.
Correct. And then I just wanted to, the other thing I wanted to bring up is in terms of the drainage, we did meet with the neighbor a number of times and we had some good discussions and I think we satisfied all of the issues and I think that went really well. And his engineer did issue us a letter also February 9, pretty recently, with a couple of additional comments. And we've gone over those comments also with the neighbor's engineer, and we're going to incorporate those comments. We'd like to incorporate in the resolution that we're going to address those 5 comments. Bill, that's this letter.
Were you,
The board wasn't copied on that, and I don't know why, so, but that, you can have
that's
that.
the letter, February 9th.
Yeah, right, from Mr. Miola, so, there can be 2 letters?
You gave me 2 letters. You gave me a letter dated February 9th.
This is my own. Yeah, so that's Mr. Miola's, and there were 5 additional items and they're minor items, but we discussed those with him also, and those are going to be incorporated into the revised plans.
Quick question, I mean, you got it, Bill, you wanna
Be
finish?
able to do soil testing for your, stormwater?
We haven't done it yet. We're up at the top, pretty far removed from the lake. So I don't think groundwater is gonna be an issue with the dry well. When they're out there with construction, we will do its inspection. We get a permeability test to prove the capacity of the soil to accept the groundwater. the surface water. From the drywall.
All right, that berm you propose, is that gonna be a concrete berm?
No, just a earthen berm.
I mean, I just wanna make sure that that doesn't, I mean, listen, we know how berms go, you get a lot of heavy water and it washes out and,
I think it's gonna be earth and grass, it's gonna be seeded, it's gonna be vegetated, that'll help.
Right.
And it's, there's not a lot of water that comes across, but we're
Okay.
trying our best to
Yeah.
keep the neighbor.
I mean, cause
And-
the adjacent property does,
It does
lower,
slope that way, yep. But I think this will be a good solution.
Okay.
Is there permission from your neighbor to put that on? Because
The berm does extend, that'll be part of our easement agreement, that the improvements that we need for the house will be included.
Will include the berm.
Yep.
And so this situation that we're creating now in terms of the drainage is an improvement to the neighbor's property to know that there's that.
Yes.
I mean, because there is no easement on that side of the property, correct? The easement on that side.
So the easement has to be redrafted.
So we got to make sure we have the easement down the middle and the one for that drain. Oh, I mean the berm.
Well, yeah, I mean, we can't approve a berm on
Somebody.
that other piece of property, so,
Understood.
I just wanna make sure that none of that water comes down and it's gotta terminate somewhere. I wanna make sure that you guys can collect it and, or send it down the line,
Down the line, to the lake where it's
Okay.
going anyway.
Okay.
So
Oh,
for-
yeah.
That's the
berm-
balance of my
Okay.
testimony. If anybody has any questions, I'll do my best to try to answer those.
If I say the burn, it will require an easement agreement between this applicant and native.
That's fine, so we'll be able to procure that.
Yeah, cause I guess all the approvals, but if it is approved, it's gonna be contingent on
On the easement.
obtaining those easements and that, ability to put that berm on that side of the property. So, okay, any questions, applicant?
In the spirit of saying something nice, I thought it was an intelligently laid out plan.
All right.
Shocking.
Because I did it.
Wow.
No, you said for the benefit of the neighbor. That was the thing.
Take the compliment.
Any other questions?
I guess, real quick, the two sheds you're building, you're planning on building it within the 10-foot easement. Do you have the option of being outside?
Within the side yard.
Side yard setback,
Yeah. Again, the lot is only 65 feet wide. If we were to build them, both of those be in the middle of the lot.
Yeah.
We're trying to keep that area more usable for the enjoyment of the homeowner.
Yep.
What's the size of this shed come?
The smaller one is
48 square feet.
48 square feet. The larger one is 10 by 16 or 160 square feet.
Small,
They're relatively small.
very small.
And again, it's just for
Late stuff.
lake stuff.
Yeah.
right?
Okay, any other questions?
So the one in front of us is for the lot number 9, correct? And then the lot number 8 is where, just for the access.
Correct.
Yes. That's a whole different lot,
Yeah.
so,
And it's interesting.
yeah, so, okay.
Interesting.
At this time, I'll open this application to the public. Does anybody from the public wish to comment on this application?
Yes, Anthony Bongiovanni. I am the next door neighbor, 55 Point Pleasant Road.
Please raise your right hand. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. So first, let me say I am in favor of the application. I think what Mr. Zaku wants to do there will be quite nice. When my engineer, Mr. Miola, and Mr. Graham have had multiple conversations. I think largely they are in sync on that. Some of the things haven't made it to the plan, so I'd like for Mr. Miola to talk about that, because I'd like that to go on the record so we're all clear. I do want to point out one thing. Mr. Graham, you said that it wasn't a lot of water. It's actually a tremendous amount of water that comes from the adjoining property onto my property. It causes very significant problems in my basement, which, has been mitigated over the years with sump pumps and French drains and things like that. And it also floods my patios, which are about 300 feet away. So it is a lot of water, and I very much appreciate the berm that's being added, because I think that will help to mitigate some of that. It is important to me, though, that berm be constructed in a manner that the water's not going to wash the berm away.
So that part is really, really important because I'd like to have something that solves the problem, you know, for years to come, so I don't have to deal with it, you know, any longer.
Have
I
you
have
seen things?
have I seen it?
Have you seen things that you would say meet that requirement of a berm that is fairly solid? I mean, what's your?
Well,
Concrete's the
have I
best,
seen
right?
things? I'm not an engineer, yeah. I don't want it to be arduous or very expensive for the applicant. I certainly would like it to be within reason, but I don't want something that's gonna be gone, you know, in a year or the first rainstorm. And also the amount of water that we get from the adjoining property tends to wash away a lot of the vegetation and plant material as well as mulch. I've actually in some places put in rocks just so it doesn't get washed away. But I mean, you know, literally I've had 20 yards of mulch, you know, washed away. There is that much water that comes down from that. So I'm very appreciative of the willingness to put the berm in because I think that will help, but I think it needs to be substantial. So
Has your engineer recommended anything specifically?
I'll let him, I'll let Mr. Miola speak to that. And, but that was really all that I wanted to say in regards to that.
Mr. Graham, would your client be opposed to putting a concrete, basically like a concrete curb
I
down
think
there?
a concrete curb is a little excessive and would be very expensive.
Okay.
And I think that might create a lot more disturbance in the area just to get the footing in
Okay.
right. Certainly, grass swales are an accepted method of stormwater conveyance. We will make sure that this berm meets the requirements and capacity so that it's done
I
appropriately.
just don't wanna see something, I mean, listen, a dirt berm and a lot of water, you know what happens.
I think this would be a maintenance component installed that should anything happen to the berm, that it be repaired and replaced as required, but again. Function and the purpose of it is to protect the adjacent property owner, and I think this is a good solution given the drainage area that comes in.
And what's your recommendation?
Third berm? Dirt with the vegetation to
What's the
stabilize.
what's the length of the berm?
The whole length?
So this
Well, it's gonna be from here to here, and then from here to here. But for his property. You can't say that yet, because that's something real. Yeah, I know.
About
How do
280.
we do that?
Oh, 280.
Okay.
Would it be appropriate to have a provision that your applicant's engineer and Mr. Giovanni's engineer work together to try to come up with an agreeable design for the berm, and then allow our engineer to take a look at it too and get a consensus?
Yeah, we're fine with that, and maybe Mr. Miola can speak to it, but we're absolutely fine with creating a berm that's gonna work.
Okay. All right.
Evening, everyone.
Step up.
Just for the record, let me, sorry, go ahead.
The testimony about to give the truth, the whole truth, and nothing but.
Yes, I do.
Your full name, sir?
Frederick C. Miola, Meola, 28 Whippany Road, Whippany, New Jersey. And just for the record, because I think the last time I was here was about 15 years ago. I'm a licensed engineer, land surveyor, planner, certified floodplain manager, and certified floodplain surveyor. And I've been doing this for a lot more years than I want to admit. I think it's at 53 now. So, and I used to be the adjunct professor at County College of Mars for 12 years when they had the surveying and land use class there. I taught them.
Okay, he's qualified.
Are you sure?
Started this.
In a little five.
I wish I was that young. Anyway, I did, Mr. Graham did meet with me out on the site. We made some suggestions. They did make most of them. Then when I got the new plans, there was some little tweaking. Now you can tell I'm getting old. I need my reading glasses. Okay.
We'll have to be old for them.
We do definitely need a driveway easement because, as somebody else pointed out, the driveway goes through the adjoining property. They want to build a house there. I don't want them causing a problem with this property having access. So I would think putting it where it is today is fine, and then we can probably put, I'm sure the attorneys will work out the wording on it, just saying that it can be relocated if necessary because of the construction. The only thing I'm going to point out is that there also should be a clause in there that they can't relocate it and take out the berm. Because part of this berm goes about 150 or 200 feet, Tom, am I right? Yeah, on the front lot. So, you know, it's got to stay.
Yep.
Okay. And the comments on the berm,
my feeling would be, I think an earthen berm is fine. You gotta just build it correctly and they gotta stabilize it. My suggestion would probably be is when they build it, put it in, stabilize it with jute matting that gets spiked down so that it gives the vegetation a chance to root before the rains come and wash it away. You know, otherwise you're gonna be replacing it 2 or 3 times probably before it completely takes. Okay. The calculations, and I looked at what Tom did, does the pit does have capacity for the additional runoff, so it's gonna take some of the roof, probably half to 2/3 of the roof, maybe even a little more than that, through the drywall, so that's gonna help reduce the runoff onto the neighbor's property, to my client's property. The soil test needs to be done though, because sometimes, and I don't think that's gonna be the case here as near as I can tell, looking at the soil survey. But if you don't have a permeable soil where the water's gonna seep into the ground, then we've built a bucket. And it's gonna fill up once and then never drain out until the next year, probably when it all evaporates. So you gotta have permeable soil. If you don't have permeable soil, then Tom and myself are gonna probably have to talk and work out a different solution, maybe putting a overflow closer to the lake and let it run off down there. So it doesn't affect the neighbor.
Does it have a history of having like high clay content in the soil?
You know, my offices are in Morris County. Most of Morris County, I can tell you where we got good soils and where we don't. I don't get up to Sussex County that often.
I could tell you in that area, the soil is pretty good, just from
Yeah.
experience in that general neighborhood.
Yeah, so I mean, we just gotta make sure it's gonna work.
Yeah, and I don't think Mr. Graham is opposed to doing test holes and doing a soil permeability test and making sure it does what it has to do.
Yep, I will provide it to your
Yeah.
engineer.
Absolutely.
Yep.
So,
The only thing is the dry well does show an overflow from the drain and then a swale that goes along diagonally across the lot towards the lake. That swale has to be worked out and make sure it's gonna be more than a little 2 or 3 inch swale. I'm thinking you probably need at least a 6-inch swale.
Mr. Graham, you think maybe you should pipe it down a little bit and then have an outlet and let it?
We could pipe it, I don't wanna pipe it to the lake.
No, not to the lake, but I'm just saying, I mean,
We could extend a pipe a
Yeah.
little further down to make sure that.
and put a nice little riprap thing at the end of it if it
Yep.
overflows.
Hope you pointed one too.
Yeah, to the lake. Yeah, because I mean, I'm sure he doesn't wanna have to be mowing his lawn and have to drive through a swale
Yeah.
across the middle. of
Yeah,
it.
you wanna have a gradual swale, you know, something that they can run the lawnmower over and not have a problem and keep chopping the top off.
All right,
and-
well, they'll address that, so.
Yeah. And then the last thing is when I reviewed the calculations and the elevations that are shown on the plan for the dry well differ from the elevations that you would get on these details. So I don't know which one's right or wrong, but they shouldn't make them both match so that there's not a problem.
You can handle that, right,
We'll
Smith,
address the detail.
for the typo?
Yes, got here.
And I'll back that up because I have employees with me too, and I sometimes wonder where they come up with their numbers, you know.
Yeah.
So those are the general things that I saw in the plans to clean them up, just to have Mr. Don Giovanni feel comfortable that it's gonna work for him.
Very good. So you're in agreement to address all these issues?
As well as that.
Okay. Does anybody else from the public wish to comment on this application? Seeing none, I'll bring it back to the board for a motion.
Motion it for approval.
Okay, we have a motion
I'll second with all.
with all the,
With all the caveats.
you got it all right, Bill, the easements and the,
Easements, they got moving the shed down.
okay, take a roll.
You got this, you got it, okay. Mr. Diamond,
Yes.
Mr. Kevin,
Yes.
Ms. Crock.
Yeah.
Councilman Kusich.
Yes.
Mr. Michaelisky.
Yes.
Mr. Rossi.
Yes.
Chairman Wright,
Yes,
Mr. Tappan.
Yes.
Mayor Galati.
Yeah.
Thank you.
I like it when neighbors get along.
Yeah.
Yes, that's the trick.
Okay.
Next.
Let me find my thing again. Hold on. Give me that one. Okay, the next application is Alexander Obleski, 59 Northwood Road, block 70221, lot 6.03. The applicant is proposing to build a new home. Applicant is seeking the following variances. One variance, steep slope, that's. Okay, let's write up.
Good evening.
Please raise your right hand. Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
And your full name, sir?
Alexander Obalski.
And you're the property owner?
I am not the property owner.
And how are you related to this property?
The property owner is my brother-in-law. We're in the process of getting it signed over. But he's having health issues right now, but it is in the works. And I do have a permission from him that was submitted to the land use board.
The power of attorney?
The affidavit.
Yeah,
Affidavit.
you want to see that, Bill, or you?
Yeah. I'm sorry, do this. Is it just the certification allowed
Yeah.
to make the application? I think we're.
Okay. You good?
Okay.
Yeah, okay.
So who's gonna be testifying tonight, just you or?
Our engineer, Mr.
Both of
Stewart.
us?
Yes.
Okay. Before I'm in.
You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Your full name, sir?
Fred Stewart, STEWART, professional engineer and land surveyor. 459 Route 46, Kenville, New Jersey.
You're currently licensed as a surveyor and an engineer,
Yes, I am.
and you've testified before this board with us.
Yes, I have. In fact, the last engineer I was just talking was after my professor back.
We'll bring him back here, I wanna see what. kind of student you are.
Get a test.
Okay, go ahead.
You wanna?
Yeah, so I'm here tonight with my wife Diana. We currently live in the city of Passaic right now. We have family who lives in Lake Hopatcong, really close by. Brother-in-law, my in-laws. So we're just tired of where we're living. Our family's growing. If you can see, my wife's 8 months pregnant. We have a 2-year-old son at home. So we want to get out of the little urban city that we're in and move somewhere a little bit more permanent, a little bit more safer and friendlier neighborhoods.
How you doing that? This is your brother's property, did you say?
Yeah, so he's signing it over to us. He bought the property initially so that no one would build a house there next door in,
You
next to my,
purchased it from your brother?
yes. So initially he purchased it so that no one would build next to my in-laws. Obviously with the housing market and the way things are, we figured a way that would be cheaper and more beneficial to us to be closer to family and build a new home
The babysitters.
and have baby, yeah, built-in babysitters.
Yeah.
If I've heard it right, she's 8 months pregnant, so we want to move this along.
Yeah.
Ain't gonna happen that quick.
I don't know, if she's up at there sweating.
Yeah,
Go there, come on.
Oh, yeah, the doctor just left.
Okay, so this development is to the, looking at the house, the new house that's already been there to the right of it, correct?
That's correct. Yeah.
Then you have a new one being built up to the left side of that house.
That new, yeah, there's one being
Okay.
constructed right now. to the
Okay.
left.
Okay.
One in the middle that was recent, 15 years ago
Yeah.
constructed, and this is the vacant. lot
Okay.
that's left out of a three lot subdivision.
I remember that. That subdivision was probably 20-something years ago.
I remember that.
That's why we're here tonight.
Yeah.
We're here basically to renew the variances. The variances have expired for properties. All three of these lots at that one point in time, I think it was back in 2008, were all approved. With these similar variances that we're here for tonight. As Mr. Ray just stated, the one in the middle, lot 602, was constructed about 15 years ago. The one on the left is being constructed now, but I believe it's almost done. This is the last lot of those three lots.
Okay.
All right. So I'm going to be referring to my plans that are revised to 9/30/25. That's the same ones that the board had in front of them. This is known as 59 Northwood Road, lot 6.03, block 70221. This is an R3 residential zone. The lot consists of 1.21 acres vacant land. As I stated, residential to the north and also to the south of the properties. Smaller over home that's located to the south.
As far as topography goes, slopes from the northerly corner, located in the section here, and goes basically southeasterly across the property down the rear of the property. There are wetlands on site. Those wetlands were delineated as part of that original project. There is a line defined by meets and bounds for those wetlands. Being that this was subdivided at a certain time frame, they are exempt from a transition area. So therefore, transition area does not exist on the property from those wetlands. There's a certain time frame when it was subdivided. I think it's up to 1988. This was somewhere in the mid-80s, the original subdivision. Since then, 2008, 2009, we worked hard for the FEMA funded properties. Now we're here tonight, just renewing variances. Right, so there's two existing non-conforming conditions on the property. That would be the lot area, 1.21 acres is what we have, 5 acres is required. Also for the lot width, 200 feet is required, we have 187 feet. So there's two existing non-conforming conditions that we need to have variances for. Just to go right in, keep going with the variance situation. We are going for a variance for disturbance of slopes that exceed 15%. Allowable, we're allowed to have 2,500 square feet. And we are going to be at, sorry, that's page. 3,625 square feet for slightly over 1,100 square feet above the allowable disturbance on those slopes. As one can see on the second sheet of my plans, there's a band of slopes up near the northerly corner of the property that we have to cross in order to get to the building envelope on the property. Okay, and just remember where that band of slopes are. We'll go back to my first sheet, which is a little more clear. We're looking at soil erosion information. So we are proposing our home basically in this section here, which is about the middle of the property. The wetlands line traverses around that area like this. That's our only developable area on the property, is that northerly corner. That band of slopes is right across here, the steep section of the lot. In front of those slopes is going to be our septic system, right along the roadway. Off to the right of the septic is our driveway. Basically, from the county standpoint, we have to have a 2% grade up from the road in order to protect the roadway from any driveway runoff. Then we go back down, sloping back down onto the property. So we're trying to work with the grade of the property. So we come down the driveway and we move the driveway at about, I think it's a 10.9% slope. We turn that, go into a side entry garage. That way we can work with the lot, work with the property. Our garage is at grade in that area there. And from there, we step up the house into our first floor. And then we have a covered front porch across the front of the house. And that goes out at grade, gently sloping downward to a swale area that is able to push the runoff from the house around the house back to the rear of the property. Now, in the rear of the house, we do have a proposed deck. And then after that, we have a set of dry wells to collect the roof runoff from the roof and retain it accordingly, and it's all based on the standards of your requirements here in the town. We are proposing some small walls on the site. The maximum height of the wall in the front of the house is 4 feet right at the corner. Again, that's just to make up some grade up in the front of the house and build up the front of the house a little bit so it doesn't look like you're looking at the bottom of the foundation. As you come around the back, we have another second wall that is located off the rear corner of the house and comes over towards the easterly or northerly property line. And that is there to support the driveway. We have to grade off a little bit in that area to raise the driveway up, make it level with the garage in order to accommodate that slope coming out from the road. That wall there again is about 4 feet, 4 foot maximum height. We have another wall, third wall, basically running along that wetland line just to give ourselves a little bit of a backyard. And that's a 3 foot maximum high wall. This will be a walkout basement. So again, we're working with the grade, it comes out very nicely.
from a grading perspective, when we built the land, with minimum amount of walls on the site.
So it'll be 2-story at the street.
Yeah.
And 3 more back.
Basically, yes, we do meet the building height requirements. As shown within our calculations, and the zone schedule, we're at 34.5 feet. Maximum 35. That's with the walkout facing.
And you've done all your septic and stuff, all that stuff done, test holes are done.
Yep, we actually have approval from Sussex County Division of Health for the septic system. The board wants a copy of it.
So you're gonna need it.
Yep, we're gonna need it. So we have it, we have that in place. We did not apply to soil conservation district just yet. We're gonna do that upon this approval. We're trying to keep our cost level down in case we do not get it.
Okay. And the well is more than 20 feet from the dwelling, right?
Yeah, the well is located off the driveway side of the house, near the northerly boundary line, right in this section. So we have a proper distance away from the septic and away from the driveways.
Okay.
So it is really a tight fit for everything, but it all works very well, considering the limitations on this site, meaning the wetlands.
Do you have to get county approval? You already have that for the access
Oh,
to
we
the
apply
road?
for that as well. We have to get that. That would be a condition of the approval if we get it. We already are in conversation with the county. So next step is for me to set a meeting, probably tomorrow, to get out there.
You have the site distances you're gonna need?
No problem with site
Okay.
distance. From the original approval, there was a restriction to have a site distance, or I'm sorry, driveway located here due to the site distance. But we need to relocate that because of the wetlands up to the northerly side of the property. Not a problem. We already checked it out, making sure it works. So we just have to set that up with the county and get that on board.
Okay. Good. Any questions are you done, Fred, or you got more?
No, I think that should do it. That's it.
Any board members have any questions? Pretty straightforward.
Yeah.
Oh, look, you good, Jude? All right, seeing none.
A quick question, what was their original design on this? Was there an original sized house on this at the original subdivision? Or
That expired.
it expired?
That
From the original subdivision, yes, but it was in a different location. Because after the subdivision came the wetlands. And that's what we have to comply with, and that's what we did.
Okay.
So this is a little smaller than the original design, the house?
Yeah,
Yeah.
and if I might add too, we are reducing the slopes from the 2008 approval. They were at approximately 3,964, I believe it was. We're at 3,600, so about 10% less disturbance of the steep slopes on the property compared to the approval back in 2008.
Okay. Any other questions? No, seeing none. I'll open this application to the public. Does anybody from the public wish to comment on this application? Seeing none, I'll bring it back to the board for a motion.
I'll make a motion to approve the.
With the county
Subject to
condition.
county approval, yeah. Which I'm sure we'll get because you've had to get it last time, you know, when it was originally subdivided, so. Okay, so we have a motion and a second?
Yeah, well, Mr. Diamond,
Yes.
Mr. Cameron,
Yes.
Ms. Crawford. Yes. Councilman Kusavich.
Yes.
Mr. Mazaluski.
Yes.
Mr. Rossi.
Yes.
Chairman Ray.
Yes.
Mr. Tappan.
Yes.
Mayor Galati.
Yes.
You, we go.
Thank you. You got it.
Good luck.
I might move the baby.
Yeah, the more important thing, good luck. with it.
Now take her out to something to eat.
Appreciate it.
Yeah, I don't know how I got this. Okay, that completes our new applications. We're gonna move on to work sessions. We have one work session. Salvatore Cuccinella, 157 Monroe Trail. 30216 lot 24. Applicant would like to discuss 157 Monroe Trail and the project he wishes to do. You are?
Sal Cuccinella. How you doing? How's everybody?
Go ahead.
I applied for an application and we have one variance on it. For the depth of the lot. 98 feet, 6 inches, I think, 98. Right, 98.
Yeah, it's, maybe you had moved the copy.
I gave,
What
yeah.
it, what it comes down to is, it's an extremely large lot, I think it's up on like 20,000 square foot range.
So he's looking to come to build a house, but he has to get a variance.
And the point is, when I denied the application because of lot width, this lot is an excessively large lot.
Yep.
And yet it's a foot and a half or 2 feet short in depth.
Okay.
98.6.
And at that point, so it's a foot and a half short. I was just wondering if the board would consider
No.
that de minimis.
No, no, no.
Okay.
If the ordinance is the ordinance,
Yeah.
you really
Okay.
shouldn't be here tonight. We can't create a tolerance on our ordinance. That's
Okay.
what it is.
So you gotta just fill a formal application
Okay.
and you only need one variance, so it
Yes.
sounds to me like it'll be fairly
Okay.
simple for you.
I
Yeah.
took his advice
Yeah,
to come over to
absolutely.
you guys, that's
So-
what, just to make sure.
All right, sorry to make you sit here all night for that 3 minutes, but,
All right, thank you very much.
all right, Top. All right, what else we got? Yes, we have to, what is it? We open the phone?
Yeah.
Bill, we're gonna go back to that,
Yeah, this is 303 Lakeside, it's Paxos. Let me hand these out and just. There's been long discussion, long application, hearing wise between the neighbors, and there were three areas of concern for the applicant's attorney, Dan Benkendorf, and I went back and forth with him and with Bern Heffley too on this. And this is an application where there was a boathouse with living quarters, and we said you can't do that. The applicant agreed to eliminate that. The question, we said no kitchen. So of course they come back and say, well, can we have a refrigerator, a sink and a microwave? As long as we don't have a oven. The language in the resolution as drafted was kitchen. So the question is, what's a kitchen? Is it okay to have a refrigerator? Is it okay to have, put a microwave?
I think it's as long as you don't have a shower and a toilet. I mean, is that what, I mean, we don't want it livable, correct anymore? Is that what they gave that up? Just for,
Think it's okay to have a sink and a refrigerator?
What does the Cox book say?
they're gonna have it either way, you know what I'm saying?
Ordinance saying, that we're in no man's land right now. What's the ordinance point to? Just kitchen? It is a definition.
Well, that's what we said in our discussion, at the meeting, was no kitchen, no separate living quarters. So the question is, well, did you intend to exclude a refrigerator,
I don't think I mean, a refrigerator, I mean, everybody has.
I would think you could probably do something that you plug into the wall, like a refrigerator and a microwave. A
Yeah.
sink is a little different. You know, you have to do plumbing for a sink.
Given experiences with New York pop-up restaurants, all you need is a hot plate and
Yeah,
you've
well,
got,
that's true.
you've got a functioning restaurant.
Then he did ask, the shower in the bath, for a shower. We just said a sink and a toilet, and I think maybe you would stick with that because it becomes to cross the line there with occupancy, but that's up to the board.
Well, is the overarching issue that they don't want people staying overnight in the?
The overarching
boathouse?
issue is, we don't want another habitation there on that lot, which is another vehicle parking and the whole thing, so.
I mean, he did have a pre-existing non-conforming with that apartment, correct?
But
And he gave that up?
I
He gave
think
it
they offered that up to
Okay.
avoid that, the use variance.
Okay.
They offered
Okay.
that.
But does that nullify then the whatever was there existing?
Yes,
Yeah,
they offered to extinguish whatever's existing.
Yeah, so.
so they're asking to put it back, just to.
Well,
Yeah,
they're asking not to put a
downstairs.
kitchen back, or no, they're asking not to put a stove back.
What do you
Stove
consider
back.
kitchen?
Yeah, what is a kitchen? Yeah,
I mean, is it a shower and a toilet and then it becomes the whole bathroom again, right?
Hmm.
So I don't know.
I would think that you would allow a toilet because it's close to the lake, and
Yeah.
maybe that's a nice accommodation
Sure,
for
sure.
older people using the lake, and a sink, probably not a shower, you know.
All right, well,
If that's a consensus of the board, I'll treat it that way.
what is the, you good with that?
Yeah.
Sink and a toilet, they can put a refrigerator in there. I mean, obviously, who wants to walk all the way back up and, back up
Put
with
your
the house?
sodas in.
Yeah, I mean, they're gonna use it as as a recreation area, so,
We've done that once before.
so
They're gonna put their soda.
they're gonna put their soda, what, your beer, whatever?
Soda.
So,
Soda.
all right, I mean, I don't,
That's
Adult soda.
a toilet and a
Exactly.
sink, that,
This was a D variance, correct?
No, because we abandoned
the
the,
use.
the non-conforming use,
Non-conforming
it's not a use variance, because they abandoned the.
We didn't hear it. We had to leave when they
Oh,
told.
all right, maybe we'll just take a poll. Andy, what is your take on? Quickly,
I have no problem with it.
okay, toilet and a sink.
Well, in the same.
Judy?
Yeah.
Yeah, fridge and, yeah, microwave, that's fine. I mean,
And the handheld.
I hope so.
Answer.
I give two. So, okay, so we got that, Ron, what do you,
That's fine with me.
good with that? Steve?
Good,
All right,
good, okay.
that help you?
Then the other question that they had was.
What is the home? What's the home?
Go ahead.
This was the parking across the street.
Oh, boy.
So they've been in negotiation, I guess, or discussion with the guy across the street. The question is, where is that? Parking, they created it apparently without permit. And what they'd like to say is applicant agrees, subject to review of a certified survey provided by the adjacent property owner to restore, remediate any excavated property to its original condition that is not the property of the applicant, with all proper plans and permit approvals provided for such restoration or remediation. Also, as a condition of approval, if the excavated property is owned by the applicant must provide proof of or obtain approvals for such excavation. I put creation of the parking area. In other words, he's got parking area across the street.
Yeah.
If the governing body approves that parking area, I think that satisfies what we have to do.
Yeah, I mean, we,
That's up to the applicant to obtain approval from the Borough of Paccon for creating a parking area across the street, excavating whatever, so.
I mean, his property, it's a funny piece, because his property actually
Extends
goes
across.
across the street.
It goes
So
across.
his
the street.
property goes, listen.
But it does, but it only goes like a couple inches back there, because if you look at the survey, it doesn't go as much as it was excavated.
Okay.
So-
He's got to get really, I think, an accurate survey of that to show.
Well, I mean, I think that's kind of what we wanted. We wanted the corners put in and say, okay, here, this is definitive. That's the end
But
of it.
wasn't parking addressed with the design of the new house such
There
that
would
they
be,
could?
there's parking.
Off-street.
Now off
But
street,
there's never enough parking.
No. Not over there.
Yeah, never enough parking.
I mean, everybody that lives in that site, everybody parks. I mean, if you can park across the street, they park across the street.
Right, but I think this parking was created over the weekend,
Right.
and by Monday morning,
Yeah,
it was there.
yeah.
So that just goes on top of everything else, and that's the issue.
I think
Is-
he's got to get a survey. Got to show where it is. He's got to satisfy the Borough of Paccon with creating any parking area, and
Okay.
that's where.
So what's that mean? They got us, what was the council approve for a parking area?
Well, it's a town road, and you have a driveway opening permit from the town, right?
Mm.
So I think effectively that's what you're looking at, is that, under your driveway permitting ordinance, to look at it that way.
This was a little bit more confused, because the
You know,
conventional lot, the conventional driveway, meaning anywhere other than Old Lakeside Boulevard, and maybe a couple of spots. Your property line and the edge of the road right away are the same line, your front property line and the edge of the road right away. In this case, the property line actually, the traveled way is
Cuts through his property.
actually on his property, the top.
The only
of
one
his
there.
property.
Entirely.
And then there's I think, if memory serves me, it's a 50-foot right of way. So that effectively this parking area turns out to be in potentially 50-foot right of way. Of course, that would be if that was filed and all those.
Well, then he would need municipal approval for any improvement within the road right of way. So you'd have to show this in a survey, and have to get the proper permitting from you folks if it's.
I mean, many people have that. Park in the right of way, but as long as we're not in the road, you know what I'm saying, like the traveled way, I mean, the road's 50 feet wide, the actual road is
But if you-
25,
Yeah,
so.
if you're creating something new and you have to look at this as though he's creating something new because he did it without
Yeah.
permits, then it requires.
Isn't that the biggest complaint, Bill? Parking?
On Lakeside, sure. People park up and down on the road and, well,
It's a tough spot right there, no,
Yeah.
no
Well,
question.
again, this goes back to it was created over a weekend, and
Right.
then when you went and visited the site, there was a specific no parking area, and calls out for this particular address only. So this parking was created by that homeowner and said there was only parking for him, no one else.
Well, I guess if it's,
And they got removed afterwards, you know, once it became to land use and everything, but this thing is gonna keep coming back, you know.
listen, if
Not going-
the
I just
actual
don't want-
corners are 5 feet in off the edge of the pavement, well, then you can't park there because you can't get off the road. So that's gonna tell you what you can do or you can't, you know what I'm saying? If his property goes back
Yeah,
10 feet up the hill, then he can,
That's
you know, but the
I'm just
corners are
thinking of
gonna,
proving up a road opening in our right of way, and my guys go down with a plow, and there's something in that right of way, and next thing you know, I'm in a mess, cause I just knocked the back of a car out of the way.
Well, now this
we
application got
memorialize
the garage, right? Approved for garage, so now he doesn't need it.
it should only exist if the municipal engineer looks at it
Okay,
and says we can do something.
it's tight enough as it
But I
is.
think, yeah,
I think there were extra considerations in the design of the house and the parking to trade off on the issue that other people's property was taken over a weekend for not the property owner's benefit. And the trade-off was, we'll give you this extra stuff on your side of the property, right? As long as you give up what is land that's not
I
yours.
think the answer really is, if he's gonna try to do this, he's gotta come back with a detailed plan.
and I would say, listen, that I need that property
Yeah.
corners.
I think
Definitively say,
Gotta come
okay,
back.
the corner is 6 feet from the road, 10 feet from the
Yeah.
traveled way, whatever it is. I mean, that's gonna tell whether you move ahead or you don't.
That is also, it's an irregular, it's a triangular shape. So it would be good to have it the disturbed area, the area that's
Yeah.
been gravelled now. Delineated on a survey, because otherwise corner is going to just drive us nuts.
So if we don't do that, the problem is never gonna go away.
That's right.
Because, you know, the next door neighbors, never gonna complain about what. So here's the corners, either you can park there or you can't. That's
Yeah.
all.
I think he's gotta get the blessing of the Borough of Pacon and our blessing too, so I think that's the,
Oh, I didn't know if you guys.
otherwise it goes.
It never ends. Just get the
Because he
corners.
said he would
and-
remove it, so we take it that way.
Yeah.
otherwise-
I mean, if he's got the room over there, great, then go
Yeah,
ahead.
good.
Yeah.
Okay, good.
Well, we thought a kitchen was stuff.
Where's the kitchen?
The hell of the parking spot, give me a kitchen.
All right, anything else, Bill?
That's enough.
All right. Okay, at this time, I'll open the meeting to the public. Anybody wish to comment on anything for the board? No?
Right?
Huh? You sure can.
There was one more issue about the window pertaining to 303 Lakeside Boulevard for the garage. Looks like it to be specified the dimension.
Okay.
303 was.
That's the
It was the
neighbor.
garage that would be blocked.
The guy's looking
by-
through the window to get out, that guy? Well, what is the dimension of the window that's there now? Does anybody know? I mean, I don't.
3x2. In the resolution, it's stating 4x8.
4x8's a little big. I mean, it's not.
Whoa.
That's, I would say like,
To match what's existing is what was
Yeah,
discussed here the night of the meeting.
so match what's
I just want
existing.
The resolution to state the same. I don't need any.
Okay. So whatever, we'll just have to clarify the resolution to make sure that's the exact same size that's there now.
There was also discussion of if on the erection of the garage, if the garage was obstructing his view and his line of sight, then the window would also be installed contingent upon the obstruction of his view.
Yeah.
You know, my biggest thing, and to put the window in upon completion of the garage. The garage is gonna be the last thing to go up. So I just wanted to if
Yeah.
we can have some language in there.
So
After the
garage
garage
is
is
fine.
built, then the window.
we'll go in.
Will go-
Well, once the
will go
garage
in.
is built, the window's gonna be whatever, it's just gonna be a window. I don't think it's gonna serve them any purpose anymore,
No.
because the garage is gonna be, you know, so, but yeah, put it in when it's done, I guess, whatever works for you. So
Okay,
we have to
we'll do
just
that.
specify that in the resolution.
And I think there was an issue about revisiting a mirror across the street that the 303 was reluctant to do, but.
5 was reluctant to do.
Okay, but if it's for,
to do a mirror to accommodate
him pulling
out of the garage.
but if that may be worth revisiting also, that just for safety, it's a
I mean, most
suspenders and a
people,
belt.
most people put their, I mean, if you feel like getting out of your driveways, I'll put a mirror up across, just for my own protection, you know, and I don't wanna make him have to put a mirror up for somebody else. I mean.
No,
the
I
guy-
meant,
Yeah.
just for safety's sake.
Yeah, the guy wants to put a mirror up, put two up, whatever it's gonna,
Yeah.
you know. So,
And, you know, since it's quiet here tonight, if you don't mind, I'd like to just say we were here a long time in December, and there was a lot of people speaking towards us, not on our behalf. So I just want to say that, like, all these things that have been made accusations against us were not to perturb any of our neighbors. It was to actually help my surrounding neighbors by not intruding on any of their, what they called delegated parking, right? So as the new people coming in, it was made clear that, oh, you can't park here, like I felt like I was in high school again. This is where I park and this is where we park, when all these parkings were in the right of way, right? So whatever was constructed on our behalf matches what's already existing. Now, were the proper things taken? Probably not, but we're doing everything in our best interest to remedy all this. I don't know if it matters or not, but we have submitted documentation to Mr. Rushke, who was the initial engineer on the situation. Most of it's been approved by the town, the zoning department. So I don't know what the next step would be. Again, approved on what is mine, right? We hired engineers last time we were here. They testified that what was excavated is on our property. So we're just waiting on the other parties to provide their documentation.
Yeah.
To prove that we have exceeded our limitations on our property.
Yeah.
So that's what I would like the resolution to state, like, if the neighboring properties would bring their surveys to the board or to the
Well,
table.
yeah, I mean, my thing is, you know, listen, to get I mean, the concern is the parking across the street, right? So if you have your surveyor just go out there and say, here,
Right.
that's your two corners,
Mhm.
then there's no other discussion, so. I think that makes a lot of the problems go away. Put those two corners in
Great.
and just say, here, this is mine, that's yours, whatever it is. And that's, because nobody can say, well, this is
Right.
mine, that's yours. The corners are gonna tell the whole story. And then you go from there. If you have enough to park over there and you whatever, then fine. But if it's closer than you excavated, then, you know, it has to be, you know. I mean, I think that's the most fair way everybody's gonna be happy that way. You know?
Yep.
So,
Thank you.
And I think everybody remembers your application.
I think everybody,
Yeah.
even the people that weren't here, remember my
Yeah,
application.
I would just say parking's one thing, but I mean, there were a number of issues like the erosion of soil from the neighbor looking at your house to the right. Just, you know, everybody's
I
just.
just want to
nervous.
make sure that it's clear the entire roadway is that way.
Yeah,
Nothing's retained, everything's naturally excavated.
Mhm.
you know, unfortunately, like when you come for an application for a new house, like what the neighbor has now and that guy has now, that
Doesn't matter.
there's nothing we can do about
I know.
that. You know, that's the rub of the whole
understand that.
thing, you know, you're gonna have to jump through
I
hoops,
understand.
but that guy's okay, because that's
So
pre-existing.
let's just go back to do what we did 80 years ago then.
survival of the fittest.
Whatever you want.
Let's just come in one night, 2 o'clock in the morning, bring the bulldozers, do what we want, and then we don't need this board here. We're wasting our time here.
Well, we're getting better at it, you know,
Well-
we're trying to do the right thing,
That's the point.
you know?
I
So-
add one more thing to that. I'm sorry, this just for the boathouse, just because I'm Deanna Paxos, everybody, so
Okay.
this is my husband. So just the question I have with the boathouse, so when we bought it, so right, there is a kitchen that was there. So my question is, there's a bathroom, but there's also a sink that's outside of the bathroom. And I want to make sure that everybody understands that. That's why there's a plumbing there. We have a sewer that's an easement. There's like a back on we pay an extra sewer bill. We have 2 sewer bills right now. So I just want to be clear that this sink, the extra sink that we have there now, we cannot keep that extra sink, or like, that's what I just want to understand. Because it's not.
Your sink, man?
It's a bar.
Yeah, it's like, it's just to wash hands. It's nothing, there's no cooking, there's nothing there.
They wash their
I
hands.
just need to understand.
I think the spirit was overnight stays and.
Yes.
Yes, that's what, it's nothing, I mean, like, the sink is there, the plumbing, everything is already there.
Yeah.
We didn't do anything, like, it's there.
You already have a sewer hookup, so you're. I mean,
Yes, we pay for the sewer.
Yeah.
So you have 2 bills.
2 bills.
I asked a year ago, if you recall, how many sewer bills do you have? You didn't recall, and you wasn't sure if it was 1 or 2. But 2 of them, usually it's like 2 structures, and that's why you have 2 sewer bills.
Right.
So
I don't wanna say nothing, but maybe you can get to 1 now, cause you only have 1,
Primary residence.
Nice too.
you know, what I mean, it doesn't benefit us.
There's
but-
an easement on the property,
Right.
right? Sewer easement.
Yeah, that
And we have
goes
the
right
big
through the-
house,
Yeah.
comes up into that
Yes,
easement.
yes.
So can I naturally feed the home, the new home that we're proposing to
Yeah.
build down into that easement and get rid of a pump?
I don't see why not,
We're
but,
not no, not here.
Not yet.
you know,
In this place, no.
Wrong board.
Have a discussion.
Yeah.
All right, that's the construction department?
yeah.
Yeah. Well, it's not gonna keep going, but
There's so many of us.
Well, my question is, so if that's like, it's there,
Is this lop sink?
it's, yeah, it's lake water, first of all, it's
Yeah.
lake water. It's literally to clean the kids off, or just, it's nothing.
Oh, yeah, they're for.
Everybody, it's lake water. It's not.
Be cleaning them.
It's nobody's living.
wash your hands real quick,
Yeah,
right?
that-
Dump some soda down
I
there.
don't have a problem with that, if any of the other board members do, I mean. No, so, okay, I guess you can,
Right,
Thank
thank you.
you.
okay? You good?
Yep, thank you.
All right, have a good night.
Thank you.
All right, next item on the agenda is we have this sustainable small, New Jersey small grant application. I think, James, you're gonna.
Yeah, I'd only like to spend the next 2.5 hours on this, so if you don't.
Absolutely not.
Okay, no, it's just an informational document to let you know
Okay.
that in the Crescent Beach Club area, there's a falls and waterfall, and it's pretty much overgrown.
Yeah.
And there's an application for a $2,000 grant where they hope to be able to clean up the property, provide an educational opportunity on watershed management. And it'll involve some reworkings. As we know from prior meetings, there'll be a placement of an educational sign. There'll be a bench put there. There'll be some invasive vegetation removed to improve the visibility and enjoyment of the area. So there's nothing proposed now for decisions. They just wanted the land use board to be made available of the items that they're planning to do. And once they get the funding, there'll be something more concrete on the table, which I guess, Bill, you'll let them know whether the items require further review.
I mean, it should be a courtesy review,
Mhm.
very basically. I mean, the drawing that you provided, that's been provided might be enough for the board. It's not gonna be a formal site plan or anything of that nature.
That's borough property, Michael.
Yeah.
It's real property to Borough Road, depending on.
And some of it's the beach club.
All right, so that, I'm looking at this thing there, that the access is actually the Borough Road that runs right to it.
Yeah.
Okay, cause I know the beach club.
Yeah. And there's an
We get a little crazy over there.
yeah, so it's more just an information
Okay.
of what's coming, and if you have any thoughts between now and when the funds are received, they'd be welcome to hear them.
Beautiful.
Okay, that's
If we
it.
could consider this the courtesy review, that'd be great.
Okay, but you're always for efficiency.
I just wanted to add, if after a heavy rainfall, if
Oh,
you've ever
God.
gone over there, it's actually kind of neat.
It is.
Yeah,
All right, it's just
Yeah.
one of those little things they'll pack on,
Had a funny
if you've
smell.
never seen it. What?
unless you're
Funny
looking
smell.
for it, it's hard to see.
The funny smell over there.
It's after a heavy rainfall,
is pretty much all the septic systems draining down off the Bucknell Trail.
I don't think that's in the educational sign.
Okay, but I'm getting at, I'm gonna enjoy it. I've enjoyed those falls my whole life. I think they're pretty.
Yeah,
They're not the cleanest, best.
but after a heavy rainfall, it's kind of neat.
It's cleaner.
Yeah.
Yeah, what do they say? The solution to pollution is dilution. So you just dilute it out.
Well, if you've ever been to Venice, Italy in the summertime, it's the same enjoyment.
All right, you good, James?
Yeah, thank you.
Okay. All right, we have no other,
7 wonders of.
items on the agenda, so Judy, you're up.
Motion to adjourn.
Good job. Adjourned.
Do we need a second?
No.